Hello, and here we are. You made it all the way to Module 10. So you are almost done with this course. So take a victory lap, or actually don't yet, wait till you finish, but you're getting closer and closer. This module will just talk about the judiciary, then we'll talk about US foreign policy. So I'm going to get this up on the screen, and I want to start with talking about sort of the foundations of the court. So you hopefully knew before you ever took this class that there are three branches of government: the legislative, the executive, and the judicial branch. And so we've talked about previous two branches, so we're now at the third branch, the judiciary, or the judicial branch, which is just the courts, simply the courts. Here's a picture of the current U.S. Supreme Court: Roberts, Sotomayor, Thomas, Alito, Kagan, Coney Barrett, Gorsuch, Kavanaugh, and Brown Jackson. These make up the current 9 justices who serve on the Supreme Court. And why do we have the courts? Of course, there are lots of courts subordinate to the Supreme Court. We'll talk about how the court system is structured, how it's organized, and how it works. So what is the purpose of it? Well, short answer is the job of the courts in general is to resolve legal disputes using the adversarial system, including things like trial by jury and the right of appeal. So the U.S. legal system, which came as sort of an offshoot of the English legal tradition, specifically follows the adversary process. And what is the adversarial system? Basically, it means that in a dispute, each party is allowed to present their version of the events, with pretty much all attempts to slant information acceptable in court. Anything short of outright lying under oath is pretty much allowed in court. So if you've ever followed a trial or a judicial proceeding, you probably know that obviously you're not allowed to lie under oath because that's perjury and you can go to prison for that. But you can come pretty close. You follow both parties' arguments. They're so far apart that it's oftentimes you can't square the two. So not allowed to lie under oath, but information can be slanted pretty thoroughly in either direction. All right. So concept behind the whole judiciary is the law. And there are really 4 components of the law I want to talk about. One is the concept of natural rights. You probably remember, hopefully from earlier in the semester, we talked about the Enlightenment. John Locke, the philosopher, who said humans have 3 natural rights simply by being human. They are life, liberty, and property. Concept behind natural rights is that these rights originate from God or from nature, not from government. So the law, in other words, isn't what a king says it is. There is a natural law that everyone, including rulers, are required to follow, and any government which doesn't do this, doesn't follow natural law, is illegitimate and should be changed. These rights can't be abridged, they can't be taken away. Another view is, and of course, all these factors go together to give us the laws that we have. Another factor, another component I want to talk about is sociological view. This is the idea that laws emerge as gradual growth of rules and customs of society. So there are certain things, rules, which are probably based on mores and traditions and aspects of our culture. One being marriage. You're only allowed to be married to one other person at a time. This isn't necessarily the case everywhere in the world. Some countries have polygamy. So we don't really have that here because probably it's not part of our culture here. Another would be common law. Specifically from that, we get the concept of stare decisis, which I probably mispronounced, but this means stand by past decisions. Generally, when a matter is before the court which involves interpretation of law, the judge will look at previous decisions related to whatever the topic in question is, see how the judge has ruled in those decisions, and follow that precedent. Most of the time they do. Not always. Precedents do get overturned sometimes, but probably 99% of the time precedent is followed, and that's part of stare decisis, wisdom of the ages, this idea that this interpretations have come down to us from from the past. Most judges and legal scholars agree with this. A few do not. Some would say that previous decisions, previous interpretations should have no bearing. The vast majority, though, would argue that they should. And if we're going to overturn one, we need to have pretty strong reason for doing so. Last but not least is statutory law. These are statutes or laws that are enacted by Congress, state legislatures, or local governments. So, all right. So there are concepts we have here. One is trial by jury. You have the right to trial by jury in criminal cases. So, and this dates back to the Magna Carta in 1215. Trial by jury replaced trial by ordeal. Trial by ordeal was doing things like tying someone to a boulder and throwing them in the river, and if they sink, they're innocent, and they float, they're guilty. Or burning them at the stake. If they burn, they're innocent. If they don't, they're guilty. So things like that. So certainly trial by jury is a step forward. Of course, jury trials for criminal cases in the United States involve 12 jurors, and they all have to agree on a decision. They involve questions of fact, and you have the right to an appeal if convicted. An acquittal cannot be appealed. A conviction, however, can be appealed. And what this means is you ask a higher court to review the decision of the lower court. And so when a court's deciding if they want to review a lower court's decision, they look simply at the procedure. And if the procedure is correctly followed, then they will usually deny the appeal. If there is some procedure which was not followed and it could have affected the verdict in the case, then they may agree to hear a full appeal, and they may vacate the conviction, at which point the prosecution can bring the charges again or not, depending on what they do. So, and these appeals can go as high as the Supreme Court, though generally only a very few of them actually make it that far, which we'll talk about. All right. How do we have the court that we have? Well, Article 3 of the Constitution and the Judiciary Act of 1789 established the judicial branch of government. Famously, Alexander Hamilton said that the judicial branch was the least dangerous branch of government. As a result of that, probably the founders' belief that the courts were less likely than the other two branches to become oppressive, the Constitution is kind of vague on what the courts actually do. We do have a couple concepts I want you to know here. One is jurisdiction. This is the lawful authority of a court to hear a case. And there are two types of jurisdiction for the Supreme Court: appellate and original. Appellate is when the authority to hear cases from lower courts, both state and federal courts. So appeal, appellate. The original jurisdiction are cases where the case goes directly to the Supreme Court. No other court, no lower court hears the case. These are not super common, but typically they involve cases involving foreign dignitaries and disputes between states. The vast majority of cases that get before the Supreme Court get there through the appellate process, but a few do get there through the original process. Judicial appointments. According to the Constitution, the president has the authority to nominate judges with the advice and consent of the Senate. This is at the federal level. So all federal judges, district courts, courts of appeal, and the Supreme Court, all justices on those benches are appointed by the president with the advice and consent of the Senate. That means that the president nominates a judge to fill a vacancy on the bench. The Senate then must vote on whether or not to confirm. If the majority of senators vote to confirm, they are approved and they are appointed to that position. And they will then serve during good behavior, which in practice means for life, unless they are otherwise removed. So once appointed to federal bench, you can stay there pretty much as long as you want, as long as you don't commit any crimes or anything like that. And this is the concept of judicial independence. This is the principle by which judges cannot be removed due to partisan disagreements with their decisions. So this gives judges the authority to issue rulings without having to worry about being retaliated against. So the idea here is, of course, that the law is the law. It doesn't matter really what anyone else thinks. The important thing is to honestly follow the law, and judicial independence, protecting judges from partisan retaliation will help protect the integrity of the law, or so is the theory. All right, judicial review. What is this? This is one of the greatest powers of the Supreme Court. And it's not explicitly written into the Constitution. The Constitution doesn't say that the Supreme Court has the authority of judicial review. But what it means in practice, though, is that the court has the authority to strike down acts of Congress or acts of the president. So the court gets final say on what is constitutional and what's not. The Supreme Court does. And this was a power established in the Marbury versus Madison decision. For the backstory here is that Marbury was a guy who'd been appointed justice of the peace by John Adams, but Adams had failed to complete the proper paperwork before he left office when Jefferson took over. So Jefferson, as president, refused to honor this appointment because the paperwork had not been completed. Marbury sued and argued he was entitled to this appointment because he'd been appointed to it by Adams. And the case made its way to the Supreme Court. And Madison's a defendant because Madison was Secretary of State. So made it to the Supreme Court. John Marshall was Chief Justice of the Supreme Court. And Marshall, to use modern term, trolled Jefferson here a little bit. Jefferson did not believe that the court should have the authority to strike down acts of Congress or acts of the president. He believed that the court should serve as advisory role only, not get final say. He also didn't want Marbury to get appointed, obviously. So Jefferson effectively in this decision won the battle but lost the war. Marshall ruled in Jefferson's in the government's favor and said, correct. Marbury, you are not entitled to this appointment. However, the reason you're not entitled to this appointment is because the section of the Judicial Act of 1789, which governed this appointment, was unconstitutional. It is thereby null and void. So Jefferson got what he wanted in the sense that Marbury wasn't appointed, but the court set a precedent that, yes, they can get the final say on what is constitutional and what's not. And so probably Marbury versus Madison, the actual decision itself is pretty boring, frankly, in terms of like the parties involved. Like nobody would know who Marbury was today if not for this decision. But it is probably or definitely the most important Supreme Court decision in U.S. history because almost every subsequent decision is going to draw from the precedent set here that the court does have the power of judicial review. All right, which is going to bring us to our discussion of the history of the court, but we will come back to that in just a moment.